Okay, let's call the next case.
SJC-12997, Town of Sudbury v. Energy Facilities Siting Board.
Attorney Bernstein.
Thank you, Your Honor. Good morning. May it please the court. My name is Jeffrey Bernstein, and I represent the appellate Town of Sudbury. I appreciate the opportunity to appear this morning. I'd like to focus on the Siting Board's determination of need for the proposed project, the board's comparison of the project to non-transmission alternatives, or NTAs, and in particular, its denial of the town's motion to reopen the proceedings. Counsel for Protect Sudbury will focus on the Siting Board's analysis of the cost of the project as compared to alternatives and the environmental impacts also as compared to alternatives. This case—
Now, Counsel, before you get into the issues, can you help me out as far as this world that you live in that's someone that doesn't practice this finds it unique? We have forecasts from ISO New England that go from 2013, 2016. Then we have a board decision in 2019. And part of the issues in this case has to do with the time that passes and the forecast that pass. But is this something that's usual in these siting cases as far as the time delays, or is this unusual?
Well, I think this is somewhat unusual in terms of the length of the case, Your Honor. And there were different forecasts used for different purposes on the record. There were 16 days of adjudicatory hearings, I believe. And then a considerable amount of time passed, well over a year after the conclusion of briefing and the board's eventual decision. So there were much more recent forecasts, which is why the town filed its motion seeking to reopen the record in June of 2019.
And I'll ask the same questions of the appellees as well, so you're forewarned. Right.
Okay.
Please continue, Mr. Bernstein.
Thank you very much. I'd submit the case arises at a very important crossroads for the siting of energy facilities in the Commonwealth. The Siting Board and Eversource and the amicus New England Power present a doom and gloom scenario if this court does anything other than simply affirm the Siting Board's decision. In fact, nothing could be further from the truth. The reality is that the dated and inflexible framework the Siting Board has applied here is inconsistent with the legislative and other recent policies of the Commonwealth to protect, preserve, and enhance our environmental resources, encourage resilience to climate change and other events, and facilitate the transition to a clean energy future. This project's a 20th century solution to a highly theoretical problem, positing a series of multiple simultaneous transmission failures, which has never occurred, and which the demand forecasts, including
but I mean, you know, we don't want them to occur either, right?
Absolutely.
I mean, Texas is a good example of what happens when you don't do what you're supposed to do, which is plan ahead and plan for worst case scenarios. Mr. Bernstein, one thing, it would really help me if you could identify what legal errors, you know, if this is a balancing test of these three different factors, you know, I understand it, but could you tell me what legal errors are made here as precisely as you can, because we owe a lot of deference in terms of how you balance these considerations. So help me out.
Thank you, Your Honor. Absolutely. I agree that the court does owe tremendous deference to the Siting Board, but I'd submit that deference is not unlimited. So starting with the determination of whether there's a need for the project, the court has to be able to discern from the board's findings, not just the recitals of evidence. The Siting Board writes long decisions, and they're very good at summarizing the evidence that the parties presented. But they have to determine the facts about the forecasting methodologies that the board found to be true and reliable. Without those, and the Packard Mills case, not a Siting Board case, of course, stands for that proposition. So that's one of the.
But again, help me out, Mr. Bernstein. You say that there needs to be a need for the project. Did they apply the wrong legal standard for determining need, or do they just disagree with your view of need? So
They,
help me again.
they didn't make findings based on these forecasts. If you use forecasts, if you elect to use forecasts, which Eversource did, the siting board has to make specific findings. There are a series of changing inputs. I couldn't agree more about the need for conservatism, but the inputs change. And before we approve a $100 million project that has significant environmental impacts as compared to available alternatives, we need to look at the situation on the ground, because it is a constantly changing situation. And in the 21st century, we're looking for resilience. Thinking about what happened in Texas, we want solutions, whether they're new transmission lines or non-transmission alternatives like storage, big battery storage, or
Mr. Bernstein,
additional.
can I
Yeah.
ask you to be more precise? What do you mean the inputs changed? What is the legal error that the siting board committed on the needs assessment? Because it seems to me they relied on ISO New England's assessment of today's needs, including the projections for tomorrow's, or is that incorrect?
No, that's not correct, Your Honor. The primary forecasts that were being used date back to 2013. And if we look at these ISO forecasts, we see that they constantly change, and that it's obviously you can't constantly revise the record because new forecasts are coming out, and you have to have some closure. And this court and the siting board have recognized that. But you also need to have inputs that aren't 10 years out of date, because what's happened is things have changed dramatically. And here we're positing the need for a new transmission line based on this N11, this series of sequential failures, which every forecast after that 2013 shows a decrease. And in fact, the town, in its motion to reopen, offered an affidavit from its expert that the number of potential violations, the number of conditions that could lead to a transmission failure was significantly reduced. And at the rate it was going, by 2025, it may well be zero. The Eversource came back and responded to our.
Again, can I, and just to Justice Wendell's question, which is the same as mine, which I still don't have an answer to. So what is the legal error on the, could you precisely define the legal error? Was it that they relied on stale information, was it improper to rely on the 2013 study? I mean, what is the legal error?
Well, one legal error is the siting board didn't make its own findings that allow the parties and allow this court to specifically determine. We have a whole host of different studies and forecasts, but you cannot figure out on the siting board's findings, because the findings are so thin, which findings they are relying on. You can't just say, well, back in 2013, there was a theoretical massive transmission failure, which we all agree would be a terrible thing. The findings don't exist. Another one is that given the passage of time, there was no prejudice to updating the record and including the new ISO forecasts, the new CELT reports, the capacity, energy, and load and transmission reports. So there are two significant errors there, Your Honor.
Well, Mr. Bernstein, if I could ask you for a moment to sort of differentiate in your arguments the abuse of discretion on the motion to reopen from the overall issue of the enhanced priority of reliability while demand is going down.
Right.
Because as I understand your argument is that we've got data that's getting old, and that your position is that there's not enough findings or documentation that, despite the forecast methodology, that there's still this need. And here's my problem, to be frank about it. I can read what you wrote, and I can, to some extent, understand it, but trying to get into ISO New England's forecast methodology and trying to figure out whether the documentation at the motion to reopen explains Eversource's new forecast methodology seems to be the type of thing where I'm going to say, okay, board, what do you think of that? How am I going to bring to bear the ability to discern whether that argument is right?
Your Honor, a couple of things. First, if you're using forecasts, they have to be reviewable and reliable. And we don't have the findings that allow anybody to determine that. As to the motion to reopen, the board denied the town's motion based on extra record evidence and based on a study that Eversource put together attempting to refute the
But
town's motion.
wasn't the motion to reopen extra record? That's the nature of a motion to reopen.
Well, we have to show,
Right.
we have to show good cause, Your Honor, and the citing board in defeating and saying that good cause doesn't exist relies on something that we have no opportunity to cross-examine, no opportunity to do any discovery.
So you want the other side to just lay down like a dog when you
No.
file a motion to reopen?
No, not at all. But what the other side filed shows that there's a significant factual dispute. And I think under the Boston Edison versus DPU case, there has to be at least a reasonable opportunity to resolve those significant factual disputes, particularly where we've shown and made a prima facie showing that based on these new forecasts, there may be no need at all, or that in fact, the ability of non-transmission alternatives to serve the need is much greater. And the record in this case shows that over the couple of years, Eversource's original prediction of how much injection, how many new megawatts of generation or savings from energy efficiency went down more than 300%. It went from well over 200 to 80 by Eversource's own estimate at the time of the motion to reopen. And we don't,
I guess
lots
finish
of
the
errors.
thought there. Mr.
Sorry.
Bernstein, can I ask you to finish the thought there? What does it mean that it went down by over 300%? Are you suggesting that there is no longer a need?
No, I'm suggesting that
What is the conclusion I'm to draw
the
from
conclusion that,
the
sorry, Your Honor,
decreasing megawatts?
what is that the feasibility of alternatives, of non-transmission alternatives, which is something that by the siting board's own decisions is something they're supposed to encourage. And in fact, I would submit is more consistent with building resiliency, that the problem that has to be solved is radically different than the problem that Eversource presented in its original petition. That's the conclusion you should draw. And that in fact, what the siting
I'm sorry,
board,
counsel, I don't understand what you mean when you say that
that
it's radically different.
the number of the amount of megawatts, the size of the alternatives, the cost of the alternatives to the proposed transmission line has changed so radically, so that the original contention that we can't possibly replace the transmission line with solar and storage or energy efficiency or other measures has to be looked at, because it's a completely different problem than what Eversource presented back in 2017.
Okay, thank you very much. We'll move on to Attorney Canoff. Mr. Canoff?
May it please the court, I'm Richard Canoff. I represent Protect Sudbury Incorporated. And I'm going to focus my remarks on two aspects of General Law Chapter 164H with respect to minimum impact on the environment and lowest possible cost. There are 2 points I want to make with respect to those elements. First, the board erred in using conceptual estimates to assess lowest possible cost for the project and for the alternatives. Second, the board erred in its finding that the All Street route and the underground MBTA route for the project and for the alternatives were comparable. And I want to start with cost. With respect to cost, the company submitted what we refer to and what they refer to as conceptual estimates. These estimates have a wide variability in terms of their scope. So conceptual estimates, for example, are a range of
But
minus.
aren't conceptual estimates, council, traditionally used at this stage because you actually haven't built it? It's not worth the cost in getting granular on some hypothetical. It's just a ballpark estimate.
Right,
I
but I
mean,
think
you know, some science behind it, but it really has to be necessarily a ballpark estimate.
our contention is, Your Honor, that a ballpark estimate under the standard of lowest possible cost is inadequate, and that the
And
companies,
what is your legal authority for that proposition?
the legal authority is that this court has interpreted the forecast and the information that a company has to submit and the board has to assess that let me say it this way, that provides enough data for that assessment to be made. Our content, and that's in Town of New Bedford versus Energy Facility Siting Board, 1992, where the court interpreted Chapter 164H. The fundamental legal point is that if you have conceptual estimates with these variable ranges, wide ranges, and you try to compare projects related to each other with those ranges, you don't have the data to make that comparison. The ranges
So
are
you're
simply-
suggesting anytime these kind of conceptual cost estimates are used, it's unacceptable under the statute.
That's correct. And there is
So
a.
do you
there
have a
is a-
sense, because I don't do this day to day, do you have a sense of how many of these projects are based on conceptual costs like they are here?
They have traditionally, in the siting board, I think, references this in the decision, and the company certainly does in their brief. They have posited that these conceptual estimates are standard in these cases and that they therefore should be relied upon. This is really one of the first
Yeah,
cases.
that's my problem. I guess you've identified the crux of it. If these are the kinds of costs that are standard to be used, are you suggesting that they're always inappropriate?
No, what I'm suggesting is, and this is, I think, the first time that this court has really looked at this issue. And I want to put a little bit of context here as part of my answer to your question, if you'll indulge me. Many of the projects over the last 10 years, if not all of them, have involved transmission lines that are under streets or on existing rights of way. So the comparison, whether it's conceptual estimates or as we would essentially recommend planning estimates, were for the same type of transmission facility, under street or on an existing right of way. This is a very different case. Here you have a transmission line basically on all elements. You have one under street, you have one on a right of way that hasn't been used, and you have one on an existing right of way. The ability to refine estimates for those projects on the basis of conceptual standards isn't consistent with what the court has said is required as sufficient data. And I want to also just make a point that the ISO itself doesn't necessarily use conceptual estimates for this level of decision making. They certainly use conceptual estimates. There's no question about that. They use it as part of their planning and assessment process. But they talk about conceptual estimates as simplified and study estimates. They don't talk about them as things that you're going to actually use to make a decision. And in fact, as you go through their process, when they make a decision, they rely upon the more refined planning estimates. And our point in this case with respect to estimates is that's the level of refinement that this court should insist that the siting board use as part of its determination under the statute and as part of its determination consistent with the New Bedford case. And I also want to just...
If I could just interrupt you for a moment, because I want to just ask a question where you started to make sure that I have the right standard to be applying here. Because you mentioned minimum environmental impact and lowest possible cost. And I think that we're going to hear from the board that you look at all three factors, reliability, environmental, and cost, and you do a balancing, and that the board doesn't have to find the minimum environmental impact, and it doesn't have to find the lowest possible cost. Is that argument wrong?
I think the argument has to be put in context with what we're saying about cost. You have to, at least in assessing costs, whether you assess it, balance it, and make comparisons, you at least have to have a metric that establishes
Absolutely. Fair
what the
point.
cost, what the
Fair point.
cost
Does
is.
it have to be the lowest possible cost?
The metric that you
Yeah.
use, the metric, my point is that the metric that you use to establish lowest possible cost has to be a reasonable calculation. And using conceptual estimates with a wide range of -25 to +50% doesn't do that. It just...
No, I get all that.
Okay.
And I certainly get the expense year to year of the lease to the MBTA. I'm asking so much more of a basic point, which is, in doing this analysis, does the board have to do what you said? Find the lowest possible cost or the minimum environmental impact?
What the board, I think it does. And I think that what the board does in its decision is it takes a look at each one of these factors individually. And in assessing cost, for example, it takes a look at the different costs as presented by the company, which are based upon conceptual estimates, and it just compares them. And it says, option A is lower than option B, option A wins. And we're saying the analysis that goes into that point reference, that specific number that determines the basis for the EFSB's comparison is too broad. You can't just take a single number based on that estimate and compare it.
But aren't you asking us to change all of the traditional standards? Isn't this how it's been done? That they use conception. Let me frame the question and then you can respond. That they use these conceptual estimates and they do a balancing. And you may not like that, and you may think that's not precise and scientific enough, but it seems like you're asking us to change the legal standards here. I just want to make, and you can, that's what we're in the business of sometimes, but I just want to clarify, are you saying that the law was misapplied or that you want the law improved?
I think that this is the first case that has come up where the issue of what the appropriate cost standard on the lowest possible cost means, and therefore...
But isn't that incorrect? Hasn't this ISO methodology been employed in the past, and the conceptual cost counting has been used in the past in all of these cases, and you want us to change it? You can be upfront about that, but what you can't do for us is not tell us what's legally wrong here, or we're going to be befuddled. Go ahead.
So yes, the short answer is that from what the EFSB has done in the past, where it has used conceptual estimates, and it has allowed the company to refine conceptual estimates to a planning grade standard, plus or minus 25%, and make a comparison of that estimate with the alternatives. It has done that consistently, with a couple exceptions, however, and I think this is really key to our ask of this course to take another look at this, or to take even a look at as a first reality. And I want to just point you to what the board itself has said about conceptual estimates as it has reviewed them by Eversource and by the other utility, in this case, New England Power. The board itself has said that these estimates should be refined in the future to, quote, incorporate a narrower range than 25% to 50% in order to, quote, provide a greater certainty about the true cost of a project. They've also said that the provision with this refinement of timely, high quality and reliable cost estimates is essential for effective review of project alternatives. So we're just echoing some of the concerns and some of the criticisms that the board itself has recognized in its assessment over time of conceptual estimates. They're just too broad, they're not accurate, they're not meaningful, they don't allow a detailed comparison or a specific.
Council, could I interrupt you on one point? Because I think there's a little bit of an amalgam of all of the justices' points to you that I'd like you to answer for me. Your brother counsel talked about that we should not necessarily defer to the agency or the board's determinations in these. And isn't this exactly the reason why we've had this jurisprudence? Because in this particular situation, you're talking about us doing a granular dive into the cost estimates. But this is in the smaller context of what happened here in this regulatory proceeding. Are we to do this in all administrative proceedings like this, where people could come in and say, let's get down into the weeds of all of the determination and all of the factors that the board has in front of them to kind of revise the way they've done things over the years? Isn't this exactly the reason why we defer to the experience and the expertise of the board?
Your Honor, there's a balance between deference that's due to the board, and there's a obligation of the court to, on some levels, review the specific interpretations that the board has made. In this particular case, with this particular analysis involving a standard that is lowest possible cost and involving a requirement of sufficient data, we believe that this case is appropriate on the issue of conceptual cost as applied here for this court's review. I understand the deference, but that's the bottom line on that.
So,
Okay,
so
with
counsel, oh, go ahead,
Oh, I'm
sorry.
No,
I'll
no,
withdraw
I
it.
have a question.
I was just going to ask, it sounds to me that you really want us to change this. You know, you're not arguing there's particular error in the findings they made, that you don't like the model they use. You want a wholesale change of that. Is that accurate?
We believe that the model that they used of conceptual estimates as part of their comparative assessment doesn't comport with the statutory requirement or the sufficient data. So I guess the short answer to your question is yes, but I also just want to point out that we're just taking what the board itself recognized as deficiencies in these estimates to a conclusion that is wholly appropriate given how inaccurate and meaningless they are for the type of review that's required.
Everybody else set? Okay, thank you very much. Attorney Cray.
Thank you. Excuse me. May it please the court, Pierce Cray, Assistant Attorney General for the Energy Facilities Siting Board. On the need issue, at points, the appellants have seemed to ask for a specific new standard to be applied, or at least that the so-called worst case standard not be. The board submits is a fully appropriate conservative standard consistent with what the operator of the regional electric system, ISO New England, uses, and it's appropriate here. In this case, and this gets to all the questions about forecasts. In this case, there was a lot about forecasts, but the board also made a separate, critically important finding. And that is that there already exists a need that that existing need dates back to 2013, and that as of the time of the board's 2019 decision, that need still existed. There have been a lot of issues raised about forecasts, but you don't need to get to what can happen in the future if already there is a need. The appellants have never explained why that separate determination of an already existing need is wrong. I'd specifically point the board to the town's main brief at page 35 and its reply brief at page 11, where it alludes to this separate finding of an already existing need, but then provides no argument as to why it was wrong.
Well, what they're saying, I think, counsel, I think what's going on here is they're saying, well, we have a motion to reopen. There's no doubt that the project need is at least reduced from the ICO New England data, that the non-transmission alternative data is better than it was in 2013, and that we want an evidentiary hearing as a result of that to test the methodology that you're using in response to the decreasing need.
Yes, Your Honor, but that is their arguments. But in the motion to reopen ruling itself, the board specifically found that the issue of already existing need had not been rebutted, and as a result, the standard for reopening these extended proceedings of clearly shown good cause was not met. Because again, you can have all the forecasts in the world, but if there right now is a present problem, which the appellants have not rebutted before this court or explained why the board's finding of that was wrong, and the board's finding was based on evidence specifically provided to it by the regional operator of the entire New England grid, that there already is an existing problem, that was sufficient to deny the motion to reopen, particularly where, as the town points out, it already is quite well into an extended case that the statute 69J has language indicating it should be completed within 12 months. Now, the courts previously held that 12-month language is directory, not mandatory, and these proceedings are immensely complicated. Here, there were 4 interveners, more than 60 other interested parties, more than 25 witnesses, more than 1,800 exhibits, 16 days of highly complicated hearings. And so it has taken longer. What the plaintiffs, appellants are asking for is for the court to rule that it needs to take a good deal longer, have it reopened so we continue to assess where things may or may not be in the future. Well, we don't need to get to where things may or may not be in the future if there is a finding of already existing need right now that has not been rebutted in the briefs that are submitted to the court. If I could turn to the
Counsel, is that because
yes.
the future need is only going to go up so that the existing need right now is a base?
No, I believe the already existing need is a separate determination. The forecasts go to what may be happening in the future. And as what was Mr. Bernstein indicated in an argument, and as the board noted, in the motion to reopen, their expert witness submitted an affidavit saying basically the closest, even under these forecasts, if they continue to go down, that the existing need would be resolved would be 2025. But the board had before it, and I would defer to exactly what Mr. Bernstein said, but that was the thrust of what I understood he was saying. But the board looked at the issue of was the finding the prior evidence of existing need, was it rebutted by what was being put in? And it considered 2 sets of affidavits from the town, 2 sets of memoranda, a principal and a reply, as well as material discussing the same sets of forecasts by Eversource. And it found that that standard wasn't met of good cause and that there was not sufficient reason to reopen a proceeding that already was well over, for better or for worse, the 12-month period that the legislature would like these important matters resolved by. That's the kind of discretionary determination the board's previously indicated in the Boxcon case, one of the alliance cases, that on motions to reopen, there is broad discretion in the board. And I would submit that this was, given all the factors, that this was sufficient.
But considering the deference that the board has, including, I guess, you're right, the deference to reopen, I mean, wouldn't we be more comfortable with that deference if there was some sort of hearing that explained Eversource's forecast methodology and explained why, despite the decrease in need, that nonetheless we need to go forward with this project?
Well, it actually wasn't, Your Honor, Eversource's forecasting. It was forecasts again by ISO New England that the town itself, in its motion, put before the court, along with an affidavit as to why those forecasts were significant. Eversource came back with a rebuttal affidavit saying, no, they aren't actually significant. And then the town, over Eversource's objection, had the right and did submit a reply memorandum and a reply affidavit arguing sort of the contrary. The board looked at it. It found that based on the papers before it, there was not enough to change the issue of the already existing need. Again, 2025 was, which is what Mr. Bernstein talked about. If trends continue, the need will be resolved. That was 6 years from the time the board was deciding this in 2019. And it has to, legislature wants it to address existing needs, not necessarily wait for 6 years to see if the needs go away. I may be overstating.
Mr. Cray, everything seems to be lagging though, right? So during the original proceedings, you're using 2013 data, right?
Yes, sir, as supplemented with 2016 ISO data. But those are the two core years. Yes, Your Honor.
So during the original proceeding, as opposed to the motion to reopen, were there objections that the data was stale at the time? Or did this just come up in a motion to reopen that suddenly the plaintiffs were not happy with the statistics that they were working from?
I don't know the precise answer about whether it was, I would defer to Mr. Rosenzweig to answer whether it was specifically brought up before. But regardless of whether it was or wasn't brought up, the standard in the regulations to reopen is clearly show good cause. It's an appropriate standard given the legislature's preference to expedite these proceedings if possible, and the fact they do inevitably take a long time. And
can I ask one other question, and maybe Mr. Rosenzweig rather than you, Mr. Cray, but opposing counsel says that the board was, I'm switching to conceptual cost for a second.
Absolutely, Your Honor.
Your opposing counsel says that the board has criticized its own reliance on conceptual cost. Is that true, or is there more nuance to that point? Can you respond to that one?
Nuance was exactly the adjective I was going to use, Your Honor. The board would prefer, in an ideal world, more detail, more development rather than less. So it certainly has statements in its decisions encouraging that. The board does not require it, though, and for a very good reason, two reasons, I should say, both of which are grounded in the text of Section 69J itself. The first reason is a requirement in 69J that, or a prohibition on any state agency from issuing a construction permit for a project until the board first has approved the petition that the court is currently has under review now. Because the board proceeding must come first, it's necessarily, you're at the early stage that some of the other justices alluded to, and that's naturally estimates are going to be more preliminary at that point. The second,
Can I just, because it's going to display my ignorance for a second. So you say there's follow-up proceedings for construction permits. Are there also follow-up environmental proceedings, or does this, I mean, we normally require, Section 61 commitments and other things in the environmental process. Will that still have to be met by this?
yes, absolutely, Your Honor. And when I said construction permits, I was referring to precisely the environmental permits that Your Honor just referred to.
So there will be there'll be an environmental process after this siting process that they have to go through. So
I believe that it starts on the time of the issuance of the board's decision and does not continue to be told during the course of this review. Mr. Rosenzweig can address it. I believe matters have progressed in terms of those other permitting. But my understanding is, at least the statute's written, you don't get to at least the issuance of those other environmental permits until the board has issued its decision, that it has to come first. As a result, because the board proceeding comes first, you're at an early stage. The second reason in the text of the statute is, again, the 12-month language. It needs to be resolved within 12 months. These, as both the amici, New England Power, and these has illustrated in Eversource as well, going from conceptual level to planning level takes a lot of time. I just conclude by noting the
so just so I can summarize for myself. So there's going to be an environmental process where they have to make a determination of all of the environmental impacts on the proposed permit, which often also considers alternatives. So this is not the only game in town on this thing, right?
Absolutely not, Your Honor. And I know Mr. Rosenzweig has details on that if the court is interested. But just my final point on the fact why the court, we are urging the court not to require as a mandatory per se rule in every case moving to this planning level cost is the time. Protect Sudbury in its own briefs twice say it would take 10 to 12 months for its preferred alternative to be pushed to the planning level. When the statute itself says 12 months, it's entirely irreconcilable with it for there to be a fixed per se rule to impose you have to go to a certain level. So the board would prefer things in the ideal world, more detail, but it also respects the reality the statute is operating under. It doesn't require them, and it urges the court not to require them either.
Okay, thank you very much. Attorney Rosenzweig.
Good morning, Your Honor. May it please the court, David Rosenzweig, appearing on behalf of NSTAR Electric, who was the petitioner and project proponent before the siting board in the underlying proceeding. I would first start by joining argument with Assistant Attorney General Cray on the issues of need and the motion to reopen. I think the critical data point here is that the need for this project is not based on load growth or load forecasts in and of themselves, although each and every one of the load forecasts that were reviewed by the siting board in the proceeding were consistent with ISO New England related studies. And the siting board properly said that they give great weight to the ISO New England, given their expertise in this area and their role as the regional system operator in New England. But the key point that I was alluding to is that the need for this project exists at load levels that have already been experienced, and none of the forecasts that were presented during the proceeding indicated that loads were dropping to an extent that historical load level would not trigger a contingency on the company's system if there were consequences with regard to other generators or transmission lines, a la in the Texas situation, that would give rise to a series of customer outages and rolling blackouts and the like. The standard the siting board applies is under its statute, that reliability is sacrosanct, and that the legislature has declared that the health and safety of the Commonwealth, its citizens, its economy is dependent on a reliable supply of electricity. That's the same standard that Eversource is held to as a transmission owner under state and federal standards. So it's very important for the company to have in place resources to address load situations that may occur in its system at the same time that there is an unavailability of transmission or supply resources to meet customer needs. That's a fundamental requirement on the company, and it's the standard the siting board applies under its statute. With regard to the question of whether the claim of the staleness of the data was made during the underlying proceeding, it was not, and that's my recollection. There were a series of forecasts that were presented during the proceeding, starting as early as 2013, going till 2016 with the 2016 SELT report. There was also some evidence on the 2017 SELT report. In each and every one of the forecasts that the company presented were ISO-related forecasts, and the siting board did find that each of those forecasts were reviewable, reliable, and appropriate. And while the historical load level in 2013 would support the need for this project in and of itself, the siting board's evidence was detailed on all of those issues, and its findings comport with its precedent of relying on ISO New England forecasts to demonstrate need for the project. So we believe that the siting board's order is well supported by substantial evidence. They made the requisite subsidiary findings and should be affirmed by the court. With regard to the use of conceptual cost estimates, it is indeed the case that those are the level of cost estimates that ISO New England uses to make project comparisons in what's called a solutions report. The company endeavors to refine its analyses with cost estimates during the proceeding and presenting its preferred project to the siting board, and did so here to a level of plus or minus 25%, which is called a planning grade estimate. But for purposes of doing the cost comparison, it is completely in accordance with siting board standards to compare projects at a conceptual cost estimate level. Those are point estimates, which represent the best estimates, the best record evidence in the case, and it allows for an apples to apples comparison without looking at the uncertainty range. The siting board looks at the most likely cost figure within that confidence level and compares the project costs to alternatives in order to determine which facility would have the lower cost impact on customers. Here, the company's project was found to be superior to the alternatives that were presented, at least that are issue here, particularly the.
And Mr. Rosenzweig, so I trust that the siting board knows the energy world. I'm not sure I trust them quite as much on the environmental world, so that when they're doing that balancing of considerations, I know they don't want to have like a Texas situation. They want to make sure they got transmission lines, and they're going to err on the side of getting a transmission line so that they're not like the people in Texas about to be, publicly humiliated. But is there a subsequent environmental process here where we double check whether this is the, appropriate from an environmental perspective? How does that work? Once you get a siting board approval, do you have to go through the normal state environmental process to approve this project?
Absolutely, Your Honor, and I can describe that. I would say the siting board does have considerable expertise in environmental matters, given the number of proceedings it has. But
I understand they have expertise, but they may have when they do that balancing, I'm not sure that the environmental is quite, the same to them as it is when it is in front of DEP and the environmental regulators. So go ahead.
So as Assistant Attorney General Cray mentioned, the project does need to undergo considerable state and local review. The state review occurs subsequent to the siting board proceeding, because by statute, the siting board is the first state permit to be issued, but the project has subsequently been through the MEPA process, has successfully received a MEPA certificate that the project adequately and appropriately complies with the requirements of the MEPA. MEPA issued what are called Section 61 findings that you alluded to. Those Section 161 findings will guide other state agencies in the review process. The project requires a Chapter 91 license from DEP for some of the bridge work along the MBTA underground right-of-way. That review is underway. All of the other state permits follow from the siting board review. And on the local level, there are permits that are being sought in Hudson and in Sudbury for grants of location, for Conservation Commission approvals. In fact, in the last few weeks, the company has received a Conservation Commission order of conditions, a favorable review for its wetland impacts on the MBTA underground right away. All of this happens subsequent to the siting board review.
And Mr. Roseberry, again, and because I'm more of an environmental person than an energy person, may understand that better. So when they did the environmental review here, were these alternatives that were presented here part of the environmental review too? That if we look up the environmental permit here, will they be comparing the three different options here in the environmental process, or were they just looking at the actual siting board proposal?
The environmental permits, to a large extent, that follow are based on the project-specific preferred approach the company has presents to the state agency. MEPA does look at alternatives, so I can tell you that as part of their analysis. But
did they look at these particular alternatives as part of that or not? I'm just trying, again, I'm not saying they needed to, I'm just trying to understand, how much of this is duplicated in the environmental process.
There is deference by MEPA to the siting board in the conduct of its alternatives review, but part of the reporting of a DEIR and an FEIR, which is a draft environmental impact report, final environmental impact report, looks at alternatives, provides the environmental characteristics of those alternatives. And MEPA and the siting board tend to try to coordinate their reviews to make sure that there's no overlap between the two agencies. And in here, there was a very detailed review of the 240 pages of the siting board's order. At least 2/3 of that order govern issues on environmental impacts, either in the routing analysis or the comparative impacts of the project to alternatives. So it's a very comprehensive review. As Mr. Cray said, there's thousands of exhibits and days of hearings that went into very fine detail on all of these environmental impacts. And before the siting board found that the company's proposed project was superior, it adequately reviewed all of those impacts as well as the costs to perform its balancing of reliability, cost, and environmental impact. So on that basis, we would ask the court to affirm the siting board's order.
Thank you very much. Thank you, counsel for all parties.